Hi everyone, my name is Daniel Chesmore, and we will continue in our series now, moving on to evidence. And just to get started, I have a chart here, but a lot of this will just be me discussing principles that we'll need for the bar exam when it comes to evidence. So we'll start with relevance. Remember that relevance is the goal of relevance here, and that relevance standard is to attempt to narrow the evidence to facts that the law deems significant. We want to save time for the court and focus attention for the tribunal on any evidence which meets the following elements. So number one, evidence is relevant under Rule 401 of the Federal Rules of Evidence if it has any tendency to make a fact more or less probable. And when we talk about if it has any tendency to make a fact, we think about anything contributing to the party's proof. We think about the key word there is tendency, and absolutely a necessary condition for admissibility under this standard. And that tendency in regards to the second part of more or less probable than it would be without that evidence applies to both sides equally, despite who has the burden. So if it's a plaintiff or defendant, that relevant standard will apply to both parties. And so the fact is of consequence in determining the action. Moving on and related to 401 is this concept of Rule 402, which is relevant evidence is admissible unless any of the following provides otherwise. And this is an area of much testing when it comes to the multiple choice. And remember that relevant evidence is admissible unless any of the following provides otherwise, and that's the U.S. Constitution, a federal statute from Congress, other federal rules of evidence, or other rules prescribed by the Supreme Court. So Congress might, in a multiple choice fact pattern, actually narrow that scope via statute, or it might be the Supreme Court in their interpretation of these rules. So always good as future legal practitioners for us to keep up to date with the law. And irrelevant evidence is not admissible. Relevance is necessary, but not sufficient condition for admissibility. When we look at facts and evidence versus facts of consequence from 401B, facts and evidence refers to the building block that parties use to establish the facts of consequence. So parties use facts and evidence to prove facts of consequence. In facts of evidence that are not relevant at first glance, they can become relevant if used to prove state of mind. Now, if facts and evidence affected defendant's state of mind, giving him or her motive for the crime, or that relates to facts and evidence, but facts of consequence refers to facts that the law says matter when resolving a particular dispute. Examples include when a witness saw a defendant drink beer cans and stagger towards his car. That's a fact and evidence. The plaintiff might present testimony from the witness, and that will be used as facts and evidence used to suggest the facts of consequence. So related under facts of consequence. In that example, the defendant was drunk, how the accident happened, the plaintiff's damages. Not related and not relevant would be something like the defendant's sexual orientation, or their gender, or their race, or their economic class, or their political views. And so things to remember about relevance: it's the low threshold that evidence must meet to become admissible. Remember that it depends on substantive law governing the controversy, is a necessary but not sufficient condition for admissibility, may evolve over course of trial, and as the trial proceeds, the parties' arguments and evidence may generate new issues of fact or consequence. So evidence that was relevant at the start of the trial may require relevance later to be admitted. It's affected by culture, of course. Notions of relevance are based on cultural assumptions and therefore are always evolving, such as in rape victims or in sexual orientation. It's a binary concept, but there is a way to speak about it. The evidence is relevant with high or low probative value, persuasive weight of evidence, and we look at the sufficiency standard, which is a legal standard determining whether evidence supports a verdict, as an evidence on its own is so probative that it might be sufficient to prove. And we look to what we call WOF. What is it offered for? What is the purpose of the evidence often? And so what is a person trying to prove by offering this evidence? It's a key question. Articulating relevance, look at an example of defendant's suicide attempt. It may be relevant in that case to demonstrate defendant's consciousness of guilt, running away, attempt to bribe witnesses. There might be bandanas in someone's pocket. One is the same color as the robber wore, but the other is not. Weak, but it's still relevant, as it has some tendency to make that defendant there and their participation somewhat more probable, as relevance is any tendency to make a fact more or less probable. And so that it's written here in this chart, fact of consequence, something that the law defines significant when resolving a dispute. It's narrowed down there. We talked about how race, sexual orientation, political views are not of consequence and really not relevant in most cases, unless you can argue that as it might be relevant to a specific crime maybe. Introduce facts and evidence. Parties may introduce evidence that has any tendency to make a fact of consequence more or less probable. Evidence excluded by danger of unfair prejudice, which we'll get into. And remember that it really depends on the claim or charge. Other examples might include perjury tax returns, where defendant's overpaying his taxes on balance is irrelevant from defendant's misrepresentation on his income. If a plaintiff was fired and is suing for age discrimination, then the plaintiff's wealth is irrelevant there. A defendant's concession on element of the case doesn't really destroy relevance. Stipulation before hearing or trial if the fact is true or exact language needed. If the prosecution wants to show a gory photo of a murdered victim to the injury, then the defendant concedes that killing occurred and victim died. But pics are relevant because it relates to element of the case. First half of the Old Chief case that we'll talk about. And we'll talk about this in the context of 403 with the exclusion for unfair prejudice, confusion, or undue delay. Remember that negative evidence can also be relevant. If it's a flight air pressure case, a plaintiff offered other passengers' testimony, defendant offered that no one filed a complaint, the defendant's evidence is weak. Other reasons why people didn't file, but probably still relevant, no accident. In a book case, accused marijuana grower offering evidence that his bank accounts showed no large sums of money, probably should have been admissible. And remember, causation is important to relevance. Cultural belief is actually irrelevant. Psychic feeling aura with other supporting facts, other examples. And evidence may be irrelevant to prove one point, but relevant to prove another point. We focus on what is it offered for as part of our analysis. Martha is charged with murder in an example. Plaintiff wants to introduce Martha's prior conviction for perjury. Not necessarily relevant to murder charges on defendant. A perjury case versus a murder case, the evidence does not relate to any fact of consequence. So we looked at the facts of consequence in that context of facts and evidence. And we look to, if Greg wants Martha to testify, plaintiff wants to introduce the same evidence, relevant for defendant's trustworthiness, as we'll talk about. And so Greg created a new fact of consequence. Now, we talked about this, but we'll go into more detail about 403 here, where prejudice, confusion, or waste of time, and how that relates to probative value. In the context of 403, the court may actually exclude relevant evidence if its probative value is substantially outweighed by danger of the following, such as unfair prejudice there. And what we mean by that is it only prohibits unfair prejudice under the federal rules of evidence. And so this review discusses the federal rules of evidence, but look to your state rules and see if there are any differences, if they've adopted the federal rules of evidence or if they've diverged. And so unfair prejudice, an example might be a defendant's suicide attempt where the defendant asks the judge to exclude it under 403. The defendant can make other inferences on the cause of the attempt, no right answer there. Lavish lifestyle where the plaintiff sued defendant for fraud, plaintiff can establish relevance, but defendant might bring unfair prejudice there. And so no right answer might be offered, but might offend some jurors, but the defendant's liability shouldn't depend on jurors' disapproval of his lifestyle. And we really want to balance relevance versus unfair prejudice there, where think about 403 as a net at the end of the river, where the higher threshold than evidence exists, but most evidence can still make it through. In another example, a prior felon defendant possesses a gun. Defendant offers to stipulate, giving jury no details on defendant's prior felony. The Supreme Court held there that the evidence of prior conviction was relevant, but that allowed stipulation because it affects prejudice. And the court held that in most other cases, stipulation usually does not create that unfair prejudice requirement under 403. And confusing the issues is another. We don't want to admit any evidence which confuses the jury or misleads the jury. We want to make the jury to decide based on a rational legal standard, as opposed to emotion. We think about any sort of evidence which makes a jury decide based on emotion instead of a rational legal standard supplied by the judge. And also wasting time or causing undue delay or needlessly presenting cumulative evidence as a restriction on the relevance standard. So anything that might waste the court's time, grounds work, are grounds that worked in the best in bench trials, others are just awkward, hard to argue. Look for those facts where it's a discretionary standard and the judge might rule to exclude the evidence based on a 403 unfair prejudice, misleading the jury, confusing the issues. Look for that as something to balance against relevance. In the Old Chief case, the defendant offered to stipulate fact of prior felony conviction. Evidence of prior conviction was still relevant, but given offer to stipulate, evidence was unfairly prejudicial. In stipulation, defendant having agreement with prosecutor about his prior crime, it did not destroy the relevance. Offer to stipulate affects prejudice. For felon in possession of gun cases, defendant's stipulation of prior conviction excludes other evidence under 403. In most other cases, offer to stipulate has little effect under 403. But remember, the offer to stipulate can affect prejudice, but stipulation does not necessarily destroy relevance. Decisions under 403 is discretionary under the balancing test. The judge may preclude, admit, or exclude evidence, is written there. And visual evidence is another example that you might think about, where grisly photos, admissible if accurately represents underlying facts. Distinguish that versus courtroom demonstrations. In the Philadelphia case, the facts of consequences, in the movie Philadelphia, classic. In that case, they tried to make it relevant that of the person's HIV/AIDS status, and that was considered unfair prejudice. Well, it should be that it's unfair prejudice having the jury see the lesions and feel sympathy discuss. It depends whether or not that's viewed as substantially outweighing the probative value of seeing the lesions. So that balancing test is where the court may exclude relevant evidence if its probative value is substantially outweighed by a danger of those three areas of unfair prejudice, confusion, undue delay, or waste of time. Computer simulations, judges tend to be critical of demonstrative evidence under 403. Demonstrative evidence is not the same item, picture, gesture as the disputed one. It has usually a less probative value. Advocates might create demonstrative evidence in a way that enhances prejudicial effect. As a general rule, if the jury sees something different from what actually happened, it's likely to be inadmissible. And so, fitting all these rules under 401 and 402 and 403 together, remember that a piece of evidence is admissible unless one of the rules excludes it. Most of the rules are prohibitive. They tell parties what evidence they can't admit. A piece of evidence, furthermore, must satisfy all of the rules to gain admission. In most cases, the fact that a piece of evidence satisfies one rule doesn't guarantee admissibility. The evidence may still violate a different rule. 403 allows us to exclude evidence that has survived scrutiny under other rules. It's a final fairness check, but it doesn't allow us to introduce evidence that other rules exclude. So remember there that 5 specialized relevance rules in Article 4 from 407 to 411. These relate to policy. Each of those rules from 407 to 411 articulate specialized application of 403's balancing test. Each furthers some distinct social policy distinct from truth finding, and relevant evidence can be excluded to advance a policy goal. So we've got some other exclusions. I think we have them written here. We have 411 here, and we do have these written here. So starting with 407 actually, and just ignore that lower piece. So starting from there, 407, subsequent remedial measures, evidence of the subsequent measures taken that would have made an earlier injury/harm less likely to occur is not admissible to prove negligence, culpable conduct, a defect in the design of the product, or a need of warning or instruction. So purpose constraints of 407, the rule bars evidence of subsequent remedial measures only when offered for these purposes, and they're pretty broad. But the court may actually admit the evidence for other purposes, such as for impeachment or ownership control, feasibility, precautionary measures if disputed, unless the defendant first controverts. So with an impeachment, defendant, witness contradicts what he said before, but leeway exists there. In ownership control, feasibility, precautionary measures, plaintiff gets into an accident because of ostriches. Plaintiff sees a broken fence and sues the defendant for negligence. 2 weeks after, plaintiff witnesses defendant fixing fence. Defendant denies liability and says it's his own. Fixing the fence might be viewed as a subsequent remedial measure, but it may be admissible to prove defendant's control or ownership of the ostriches and fence. Repairs by third parties really don't count there. An advertisement of warning about danger of lightning, 1 person, 1 year. While using a landline phone, defendant argues warning would cause more harm, preventing police from calling people from calling 911, cause more harm than good. Admissible to show feasibility, where defendant may show evidence on how it wouldn't be possible to take a precaution, then the plaintiff can slam the opponent with subsequent remedial measure as an objection. So we can't use subsequent remedial measures in general to prove negligence, culpability, design defect, need for warning instructions, but we can use it for impeachment, or if it's disputed, to prove ownership, control, feasibility of precautionary measures, which is distinguished and makes for a really good multiple choice question. And so the key question is the party trying to prove liability or some other relevant fact? And policy there is encouraging defendants to fix dangerous conditions out of fairness. So we can't really use it to prove negligence or culpable conduct or defect in product or design or need of warning. Otherwise, it would violate 407, but we can use it for impeachment or to show ownership, control, feasibility of precautionary measures, which is distinguished from proving guilt. So just look at the purpose of why the evidence is being attempted to be admitted. 408 is another area, and I have 408 written here. 408 in this flowchart. In this example there, under 408, we look to civil settlements. So following evidence, giving, receiving valuable consideration in a compromise or attempt to compromise a claim, conduct or statement made during compromise negotiation really relating to bilateral discussions or concrete settlement offers where attorneys are involved. They're not usually admissible to prove liability, invalidity of a disputed claim or its amount. For 408 to apply, the problem must have matured into a claim. It is admissible, however, to prove bias or prejudice of a witness when one plaintiff settled with defendant, got paid, and made an inconsistent statement. It's not excluded. Or to negate a contention of undue delay, or prove an effort to obstruct a criminal investigation or prosecution. But the policy reason behind 408 in that objection is to encourage civil settlement and allow parties to make admissions and settlements balanced against 403. So defendant steals election signs in plaintiff's backyard. Would 408 exclude those statements? Where the defendant says it's in the trash where it belongs, that might not be excluded. It's not a negotiation. However, the defendant says we can resolve this just between us. Plaintiff said nothing. It's not excluded. It's a unilateral offer. So look for that bilateral offer requirement. During negotiation, defendant says, I'm sorry. It's excluded. However, it's to establish liability. Defendant might want to use his own statements, I'm sorry, to reduce damages at trial. That's excluded. Prevents parties from introducing evidence of their own statement to impeach their prior statement. Plaintiff wants to use defendant's I'm sorry to impeach defendant's statement made on stand. It's excluded. Defendant with the plaintiff, but city prosecute defendant for stealing sign. The city cannot use defendant's statements as evidence. And remember that 408 applies to both criminal and civil cases with exception. Criminal case statements made during negotiation with a public office exercising regulatory investigative enforcement authority is admissible in any subsequent trial. Both prosecutor and defendant can invoke, but most likely to benefit the prosecutor. And so in our chart there, which is very useful, we first asked, did the offer, acceptance statement, or conduct occur during a compromise negotiation after a claim had arisen and in connection with a claim that was disputed? If it's not to any question there, then most likely it's admissible. under 403. However, if you're answering yes to all three of those questions, then you have to do a further analysis where is the evidence being offered to prove the validity or the amount of the disputed claim, or disprove the validity of the amount, or impeach a witness or inconsistency. If no, then it's admitted. If yes, then you have to ask, is it a criminal prosecution? If it's not, then it's not admissible. If it is, then further ask if the compromise negotiation relates to the crime of public office, exercising its regulatory, investigative, or enforcement authority. If not, then it's not admissible. If it is, then you have to ask, is the evidence, if the evidence is other statements or conduct, then it's admissible. If it's an offer or acceptance of a settlement, then it's not admissible under 408. So remember, you have to have all those requirements. The settlement offer or anything related to it has to be after the claim had arisen, during compromise negotiations, or in connection with a claim that was disputed. If that's yes, then you have to ask a few more questions. If it's proving the validity of the amount of the disputed claim, or to disprove the validity or amount, or to impeach a witness through inconsistency. If it's a criminal prosecution, then if it's not a criminal prosecution, then it's not admissible. If it is a criminal prosecution, then look to the compromise negotiations related to whether they claim public office, and if it exercises regulatory, investigative, or enforcement authority. If it's not admissible. If it is, then ask if it's other statements or conduct, then it might be related if it's a public office, in that public office exception. If it is, then we'll also ask that question, is it an offer or acceptance? Then it's not. But if it's evidence related to other statements or conduct, then likely it's admissible. And so next there, we'll talk about 409. And I have it written here, where no evidence of offers to pay medical expenses, payment of medical expenses to prove liability for injury, but evidence of an offer or promise to pay medical, hospital, or other expenses, or actually paying such expenses that arose as a result of an injury is inadmissible to prove liability for the injury. So if a plaintiff is injured, defendant tells plaintiff what it will pay for plaintiff's medical expenses, and the plaintiff sues for negligence. The defendant's statement is not excluded under 408. It's a unilateral offer, but can be partially excluded under 409, where only offer on medical expenses excluded, not on replacement wages. It's a very narrow rule. This policy encourages people to pay for the injured, and so you're going to have to balance usually 408 against 409. Like if it relates to a settlement offer, usually if it's a unilateral offer and it's not really compromise negotiations, because that implies like a bilateral relationship, then look for whether or not it might not be admissible. It might be admissible under 408 because it's a unilateral offer, but it may be inadmissible under 409 because that relates to medical expenses, where it can be partially excluded, but only that portion on the medical expenses. So very interesting, a lot of possible multiple choice questions. The bar loves testing on these, where you kind of balance between both those rules. And so remember the policy reasons. It encourages people to pay for the injured, and just balance 408 versus 409, where 409 needs to be in the context of a claim, so it's kind of broader than 408. However, impeachment for inconsistent statement is prohibited, but impeachment for bias is allowed, where we want to protect candor during negotiation, but bias, impeachment would not have the same chilling effect. So next on our list, 410. I believe I have it written here somewhere. But yes, for 410, criminal plea bargaining, evidence of the following is not admissible against a defendant who made the plea or participated in the plea discussions, a withdrawn guilty plea, a nolo contendere plea, which allows courts to assume guilt for sentencing purpose, but not admission of guilt for any other purpose, a statement made during a proceeding on either of those pleas, a statement made during plea discussions with an attorney for the prosecution. It's not admissible even though it did not result in those pleas. And so 408, that chart kind of touches on a lot of this. This 410 applies to both civil and criminal cases. Prohibition only applies against the defendant. It prevents litigants from introducing evidence against a defendant who participated in the plea bargaining process. Does it restrict the defendant? He can introduce statements against the prosecutor if the case goes to trial, or use statements in civil case. Prosecutor admitted during discussion some of the eyewitnesses failed to pick you out of the lineup. That would not be precluded under 410. No protection for final guilty plea entered, does not exclude evidence. If a plea has been accepted and defendant is in jail and the plaintiff makes a civil case against the defendant, plaintiff can use the defendant's finalized guilty plea because it is a conviction. Therefore, 410 doesn't apply. This applies to criminal plea bargaining and does not apply to the convictions. But the judge might exclude that under 403. So excluded inadmissible when offered for any other purpose except only admissible when offered for one of the two narrow purposes, when necessary for completeness. Defendant introduces statement and another statement should in fairness be considered contemporaneously. When used in perjury prosecution, very narrow circumstance, admitted statement must have been made during oath, on the record, and in the presence of counsel, basically in court while the plea was being considered. Statements during plea sessions won't satisfy. There's no protection for confession. Confession evidence never gets excluded. And the policy reason there is to really encourage plea bargaining. And so the key question, was a defendant confessing or plea bargaining? When did the plea bargaining begin or occur? If it's during interrogation, the police often tempt confession with promises of good treatment, creating aura of plea bargaining. And think about a two-part test to help you in your analysis there, where if the defendant subjectively thought he was negotiating a plea, that expectation was objectively reasonable under the circumstances. Look to different factors suggesting plea bargaining. If the courts tend to be against the defendant, finding no bargaining, involvement of prosecutor or defense attorney, charges already filed and specific terms discussed, government expressed interest in defendant's offer, and absence of caveat statements. Please note there that under 410, 410 has relatively little impact right now because of waivers. Most U.S. attorneys won't hold plea discussions until the defendant waives Rule 410. If there is no waiver, it's probable not a plea bargaining session. The government needs to hold defendant to promises to cooperate. If the defendant backs out, the government can use plea in prosecution. And the policy issue. So 410 was adopted in part to protect the defendant in process in which government is much more powerful. When legislative and judicial branches have made that decision, it seems questionable as policy matter for executive to overrule through waivers, but that's what is happening. And last for this video, before we move on to our topics on hearsay and character evidence, which should be separate videos of their own since there's just so much to cover there, is this concept of liability insurance, where evidence on whether or not someone has liability insurance, it's inadmissible to prove negligence or other wrongful conduct. But it's admissible for other purposes like proof of agency, ownership, or control, kind of like what we talked about with the settlement, with substantial remedial measures. And let me just check one thing before we finish there. And just think for 411 there that the policy reason behind that is encouraging people to obtain liability insurance. But we can admit not to prove guilt if someone doesn't have or does have liability insurance, but really for proof of agency, ownership, or control, or proof of bias or prejudice of a witness. And proof of bias is also acceptable under the 408, kind of similar to 411. An example is a college team coach asks if the basketball player can pick up a high school player. The player got into an accident. The high schooler was hurt and sued the coach. The high schooler wanted to introduce evidence that the player did not have car insurance. The question is whether the coach acted negligently in asking the player for pickup. Did he know that the player didn't have car insurance or a driver's license? However, whether the player had car insurance or not is a bit off from the point and is not considered relevant and cannot be used, and the absence of that insurance cannot be used to prove guilt or negligence or liability for that injury. And so that is our topic on relevance. We'll move on towards character evidence. We might review these topics later. We also need to talk about impeachment and hearsay, which are really beasts of their own. And that is it for now. So thanks for watching this, and please watch the next video if it helps, and feel free to comment if I can answer any questions.